Try that.
Okay.
All right, welcome everyone. Thank you for joining us to talk about trial skills. We're about halfway through our 13 episode series on basic skills this year, and we may just start over at the beginning of next year and do it again. We'll get some feedback to see if there are things people want added or subtracted or whatever, but this is my favorite topic in the series. Trials are my favorite work thing to do. And I've been here almost 30 years. I've had a chance to do most of the kind of trials that we do a lot of. When I started as an AmeriCorps attorney, my first trials were divorce trials, child custody trials, and I've continued to do restraining order hearings through the Domestic Violence Project. When I became a housing attorney in the late 1990s, I did a bunch of eviction defense cases for several years before there was an eviction defense project. And then I kind of shifted to more affirmative litigation, and I've done a bunch of fair housing trials and trying to preserve affordable housing cases, homeless rights cases, civil rights cases involving the police locking people out or excessive force against homeless people. And of course, they're all different, but the skills are remarkably similar. Same with administrative hearings. The skills that we're going to be talking about today are transferable amongst these different kinds of cases. And so hopefully, no matter what area you practice in, and no matter how much trial and hearing experience you have, that what we're going to talk about today is useful. The second thing I want to say before I pass it off is just, I think it's really important. I mean, not only are these the tools of our trade, but our ability to take our cases to trial and to hopefully occasionally prevail in those trials is really helpful. I mean, first of all, some of our clients really need to have their day in court. They need to be heard in court in a way that settlement just will not satisfy. Of course, the opposite can be true as well. But I do think that in addition to that, our reputation in the community is enhanced when people know that we can take a case to trial and we can win, and that affects our ability to successfully settle all of our cases. So I would just encourage you to, no matter where you are on the spectrum of loving trial or hating it, that your goal be to kind of move to some place that's further down the spectrum toward wanting to go into the courtroom and wanting to try cases, because I think you'll find over time that it becomes easier and less stressful and more enjoyable, and it is really important to our mission. So I will hand it over to Kelsey or Melanie.
I can go next. So, hey, I am Kelsey Heilman. I know a lot of you, but not all of you. So I'm a senior staff attorney in the Portland Regional Office, which is really the combined Portland and Salem regional offices of Oregon Law Center. And I'm a generalist. I do lots of different kinds of cases, although I don't do family law. So I have never done a FAPA hearing. And I am here today because Ed is a very experienced trial lawyer. I'm an experienced lawyer, though not as experienced as Ed. I've been a lawyer for about 14 years, but I am not an experienced trial lawyer. Or at least I wasn't until very recently when I did two jury trials pretty close together, one in federal court and one in state court. So the purpose of me being here is to bring the perspective of someone who just did a couple of my first trial experiences and absolutely my first jury trials, and talk about things that I didn't expect or things that I thought were harder or easier, as a complement to Ed's experience having done this a lot. And I have 2 points that I'm hoping you'll walk away from. The first one is trials are intense. They are really stressful. They're exciting. They can be fun. You don't have to love them like Ed does to appreciate parts of them and to understand that they're a really important part of the work of the full scope of services that we can do. And among other things, like I'd said, just the other side knowing that we're willing to go to trial and that we can do a good job at trial, it just puts more power behind everything that you do. And it also changes the way that you think about your cases from the beginning, or at least it's done that for me. And then the other point I hope you walk away from is I think there are probably a lot of lawyers on this call who are newer attorneys. And then there might be some people like me who've been attorneys for a while, but haven't really been trial attorneys. And my message for you, if you're someone who feels scared of trials, is that you can do them and you should, and it will make you a better lawyer inside trial and outside trial and all the other things that we do. Melanie?
Hi, everyone. It's nice to be here with you guys today. And I am just here to talk about how I supported Kelsey and one of our other attorneys in that trial, one of the trials that she was part of. I am one of the paralegals at our Portland regional office. So I've run into a couple of you that are here today. So I'm just here to talk about, from a paralegal's point of view, what that looked like and how I was able to support the attorneys and our clients throughout this entire process. And I'll hand it back, I think, to Kelsey.
I think the thing that I'm going to say now is just that most of the trials that we do as legal aid lawyers are not jury trials. And so we are going to say some jury specific stuff, but it will be at the end. We're going to focus first on all the things that happen in a jury trial and in a bench trial.
Okay, so now I'm going to start. We're going to kind of do this chronologically, more or less, and think of these as like little mini trainings on these individual skills. We're going to try to break down the constituent parts of a hearing or a trial and just talk about how those things work. And of course, this is like a very main points, the big points to be made. Each of these topics could be, much longer trainings, but we're going to start with opening statement. And just to state the obvious, we call opening statement, and we call closing argument. And we're going to talk about closing later, but the reason that one is a statement and one is an argument is at the time that you give your opening statement, there's no evidence in the record. Nobody has testified. There have been no exhibits admitted. And so it's important that you talk about what people are going to hear going forward. So you use phrases periodically during your opening statement, like, you are going to hear X, you are going to see Y, you are going to hear testimony that, there's going to be evidence that. You have to say that from time to time. And, I want to talk about that a little bit more, but I think opening is kind of an art. And the great thing about opening statement is it's the one thing that you can control. For those of you who've done a lot of trial work, after opening statement, lots of different things can happen. But opening is your opportunity to bring information into the courtroom in a organized, concise, persuasive manner. And things may go differently after opening. And so I always prepare one, and I always do one. I notice judges will often ask, counsel, do you have any opening remarks? And people will often pass on that. Unless there's some really unusual extenuating circumstance, I never pass on that, because it can be 1 minute, it can be 2 minutes. I mean, sometimes in bigger cases it's an hour, but I think it's really important to frame the main factual issues and the main legal issues in the way that you want them framed. Get the decider of fact focused on the things you want them to focus on. So the big secret about opening statement, even though it's not argument, is that it really is argument. And you just have to argue without technically arguing. And so all the studies that are out there about trials generally, and particularly jury trials, you know, point to opening as being way more important than closing in terms of the outcome of the case, because it's really often the first time that the judge or the jury is hearing things. And so just because it's called opening statement, this is not an invitation to go into robot mode and read a written statement. This is really an opportunity to bring your storytelling skills and your persuasive skills into the courtroom. And you know, everyone has their own style, and not everyone is a performer. And some of us kind of perform in a non-performer way. But whatever your style is, in opening, it's really important to begin that bonding with either the judge or the jury. And so you want to connect with them. And, you know, I think that there's plenty of space for reading things and, you know, various tech options in the courtroom, but really just stepping away from your notes, even if it's just a half step, and looking at the judge or the jury and talking to them and trying to connect with them during opening is really important. I mean, it shows that you're, you know, that you're familiar enough with your case that you can talk about it without looking at paper, and also that you care about this and you can bring that sort of passion. But you don't want to argue. And I have been interrupted by a judge in front of a jury for arguing during opening statement. It is a suboptimal position to be in, because immediately the jury's like, this dude's not playing by the rules. And so you want to like be aware of where that line is, but also it really is a time to frame the issues. So the goal is to build trust, but it's the first building block of trust that you're putting out there. So you're basically making a promise in opening statement that you are going to say you fulfilled in closing argument. For that reason, if you're not sure about how something is going to come out, or to put it, you know, in reality terms, if you're super unsure about how something is going to come out in a hearing or a trial, you don't want to get too far out on that limb in opening statement, because most of our hearings and trials are very short, a couple hours, maybe a couple days if it's something really complicated. And so the judge or the jury is going to remember what you said. And the goal is to pick things that you are relatively certain about, so that when you do closing, you can say, remember this morning when I told you you were going to hear X? Well, guess what? You heard X. And then, you know, we'll talk about closing later, but it's that tying of those things together that is important about opening. And then the last thing I'll say about opening is that, ironically, I have notes, even though I was just talking about having notes, but I would just point out this is not an actual trial. So I think visual aids can be used. I have mixed feelings about tech in the courtroom, and my comfort level is sort of minimal. And I think that Melanie is going to talk a little bit about some of that stuff later, but but I think in a longer form opening, it is, did something weird just happen to anyone else's screen? Oh, okay, good. My computer's acting up. I think breaking up opening can be useful. And the way that I normally do it is with a little poster like this that has a chronology on it. That looks really tiny. Like most things, it doesn't work on Zoom like it does in a courtroom. But the good thing about having a poster, and I know you can do this like in federal court, you can throw it on the Elmo and it goes on into the jury box or whatever. And in state court, you know, there's usually some sort of tech option. But the nice thing about a poster is it forces you to get closer to the judge or the jury and to walk through things like a chronology like this. The important thing is in red there, it's no surprise. And you can also, like in opening, if there's one like super key piece of testimony, you can like blow it up with from the actual deposition transcript and sort of read, you're going to hear X and Y. You can use deposition transcript for anything. And then, you know, for like a couple $100, you can have fancy things like this printed up in complicated cases. I won't explain what a unit year is, but this was a preservation of affordable housing case. And you can like, you know, it just kind of provides a visual backdrop to what you're saying. And also it gives people something else to focus on for a minute. If you have a 2-minute opening, I wouldn't distract with any of that stuff, but if you have a longer opening, at least, I mean, again, other people do it all through PowerPoint or whatever. I've seen that, but I really think that direct connection is the most important, but then maybe having 1 or 2 visual aids that give people something else to look at. So I will leave it there and pass it to Kelsey.
Yeah, so that leads well into the things that surprised me about opening. So I guess one thing that wasn't surprising, but that I think is key to emphasize is people people have very short attention spans, and I don't know if they're actually shorter now than they used to be, but they're short right now. And so that seems really important to think about. I mean, even judges are subject to this too. How are you going to keep the person's attention? And what Ed was saying about that connection and getting closer and having visual aids and all of that, all of those are ways to keep attention. Another way to keep attention is to think about really how long should my opening statement be to get the message across that I need to get across. I mean, there's no rule that you have to talk for an hour because the judge would let you talk for an hour. And I think I'm sure there are very complicated cases where you need to give an opening statement that's hours long. But in most of the cases that we do, even a more complicated case, a good opening statement is probably 10 minutes long or 15 minutes long. It's pretty short. So that's one thing. The other thing, something that I didn't know, is that you can use exhibits in your opening if they are pre-admitted. So if everybody agrees they're going to be admitted, and also even if they're not pre-admitted, a lot of judges will let you use them as long as there's not going to be it's not in dispute that you'll be able to get it in. So you might need to lay a foundation through a witness on the stand, but it's not like there's some big hearsay dispute that's going to have to be resolved to see if it can get in front of the jury, or if it's a little different with judges. So that's super useful. I mean, Ed mentioned deposition transcripts. So in the case that I just did in Polk County, we used, it was a case that was about keeping a child safe at school. And so we used the school's written safety plan as a key exhibit in opening to show the jury from the beginning that there was a plan in place to do a thing that the school absolutely did not do. So the plan said supervision at all times while in the bathroom, and there was an incident that happened while the child was unsupervised in the bathroom. So using exhibits in that way is really useful. Using a photo of your client, I think, can be nice. Using a photo of, I worked with Ed on an FED trial once, and we started with photos of the client's house, because she kept it really nice and she had like a really nice, garden out in front. So things like that, I think, can be really helpful. And like Ed, I think visuals are pretty important. But I also think they should be used sparingly. So you don't want 18 poster boards, and you also don't want a 30-slide PowerPoint slide deck. So in the case that Melanie and I did, chronology was really important. So one way of talking about timing is what Ed just showed, is like a poster board that's got all the stuff. We did use PowerPoint, but it was a single PowerPoint slide with a calendar. And we used animations to make each event appear in the calendar page so that the jury could watch as the things happened in order, and we could highlight things that happened close in time. So that's what I have to say about opening statement. Melanie, you watched opening statement. You helped us get ready. You have any thoughts about this?
Yeah, I mean, from a spectator point of view, I think that it's just, as Kelsey said, there's different increments of time that someone's going to have for opening statements. But I noticed observing, a lot of my time was spent when I wasn't doing technical stuff, observing the jury. And I can just tell by what Kelsey and Emily put together that the story was very important from the beginning to people. So having, like she said, a chronology that calendar that we were able to use, and wrapping a story around that really, I think, allowed people to pay attention longer because they were just really interested in what we were saying and the chronological order of the story that we were giving to them, knowing that that was going to be like vital information for the rest of the trial.
Okay, do we want to pivot to client and witness management, which is also your area of expertise, Melanie?
Yeah, before we do that, Ed, I just want to interrupt you to say we did not say we are happy to take questions throughout this presentation. So if something occurs to you right now about opening statement or something occurs to you later, feel free to raise your hand and we'll call on you or put your question in the chat, and we're going to try to answer questions as we go, as long as we can fit that into the flow. Oh, and we have one already. So Bernadette asks, do you have any thoughts about waiving opening statement when you have submitted a trial memo?
I like to do both, just because why not take two bites at convincing the judge? I think trial memos are super important. I mean, most judges in Oregon, federal and state court, are very prepared, and if you get them the trial memo the day before, they will read it. But if that happens, it affects what you do on opening, and so you don't want to dwell on the details of your trial memo. You can really be concise and much more kind of punched up in your opening. But I like the idea of, of doing both. Okay, Melanie, you want to talk about client and witness management in the courtroom?
Yeah, sure. So I'm sure most of us know that this is an ongoing process, preparing our clients for trial. So it usually will start by weeks ahead, going through questioning and how to prepare them for that. So specifically focusing on things that I supported with during the trial for client management. One thing that is important, I think, to keep in mind, especially with a lot of our clients, is that it is their first time ever for some being in a courtroom, and it can be a very daunting process knowing that you're going to walk into a federal building. For some of them, that's a big scary thing to have to do. So one thing that we did and took advantage of was planning a time and asking the client if they would feel comfortable with visiting the courtroom before trial. This helped us, get them familiarized with the layout of the room and kind of seeing it in person, and being able to have Kelsey or Emily walk them through where everyone was going to be sitting, what the layout would possibly be, really helps kind of put them at ease for a little bit and allow them to ask questions about what type of setup would be important to them in order to make it more comforting. Another thing was giving reminders to them about having eye contact. For our clients specifically, they were Spanish speaking, and we did have the use of translators in the room with us. So we're keeping in mind and reminding them that it is important to have eye contact, not necessarily with the person that is translating everything going on, but rather with the jury or the judge, opposing counsel, just keeping in mind that that is who their audience is. So you want to have them, not seem robotic, and keep in mind that they want to make eye contact and talk to the jury themselves. Another thing that we did was giving them, I kept in contact with our witnesses and our clients prior to each day of trial. So I would be in contact with them to make sure I met them outside of the building, reminding them every single day the things that they would need to get inside the building was important, just because sometimes, like I said, it's their first time in a courthouse, so they're not aware of what kind of identification they might need, what is allowed to be brought in, that sort of thing. And then also during the break times that we had in between trials, it can sometimes be helpful to have someone just support and update family members or people that are in the room. So just letting them know, not necessarily how you think it's going, but like just giving them information on what's been going on, when, if they're a witness, when they should be appearing, texting them ahead of time just to make sure that they're giving themselves enough time to arrive, and coordinating all of that with them is pretty important. Yeah, I think that's most of the notes I have. Kelsey, you want to add something there?
I mean, it really varies based on the client. So I think to your point about it's intimidating, it's a good idea to ask your client how they're feeling about trial in advance of trial. So a good example of why this is important is sometimes they have beliefs about trial that are not true and that are causing them a lot of anxiety. So in the case we just did in Polk County, my client is a child. He's 12 years old, and he had to testify. And so in getting him ready, I was talking to him. I said, well, are you feeling nervous or worried about any part of the trial? And he said, yes. And I said, well, what are you feeling worried about? And he said, well, I'm worried that because of what I say, it won't be good enough and we'll lose, and my family will lose their house. So he was carrying around this idea that his family could lose stability and lose a bunch of money if he didn't, perform in a certain way. And he hadn't told anybody that. He hadn't told his mom that. He just like sort of came up with that in his own head. And so, of course, I was able to explain that there was no scenario where his family was going to lose money as a result of the trial. And I think that helped him going into the trial. And, he's 12, but like Melanie said, this is often the first experience in trial for people. If they've seen trials, they've seen them on TV. And so they might have all kinds of beliefs and expectations that are causing them extra worry. When you get inside a courtroom, lots of parts of it are pretty slow and boring. And I think that is temperature lowering for a lot of people. So having conversations with your client about that ahead of time, I think, are important.
Yeah, I don't really have a lot to add to that other than, listening to Melanie talk about what she did makes me think that whenever possible, there should be a person assigned to do that, because if we're going to give trauma-informed services, we really need somebody who's not actually doing the trial, who can communicate and sort of manage people's understandable range of emotions during this sort of rare experience. And, like most of you, as a legal aid lawyer, the vast majority of the cases that I've brought to hearing and trial, I've been the only person there with the client. And first of all, there's many reasons why you can't do all of that at once effectively. You can try to do your best, but if you have a second person, I really, really, really recommend that. So, okay, should we pivot to direct examination here? Okay. I'm going to talk for a little bit about direct examination because it is not the most glamorous part of trial practice. You don't hear people bragging about how great they are at direct examination. And yet, just like studies show that opening statement is more important than closing, we win or lose our cases based on our own witnesses and our own clients. And so just looking at the result is more important. Secondly, over time, I've come to believe that part of our function in the community is to help our clients bring their stories into courtrooms. And the way we do that is through direct testimony from our clients. That's the best way to do that. And I think we're good at it. Like, I do think that legal aid lawyers and advocates in general are good at this. And most of it's prep, and we're not talking about prep exactly, but so I'm going to talk about mostly what happens in the courtroom, but I do think that the key to being able to do a successful direct is to work with your client to figure out how they talk about their experience, that the case, whatever the case is about. Some people talk too little, some people talk too long, and trying to develop that sort of back and forth rhythm of how the question and answering works is sort of the magic of direct examination. And so it takes preparation, but also you have to know when to stop preparing. So the key is to find that sweet spot where the client trusts you enough to give short answers that you're going to ask some next question, and you kind of get into that habit, but you don't do it so many times that it sounds rehearsed. And so it's a very difficult spot to sort of land on, but that's kind of the goal of it. And I think that when I think about direct, and this comes from both trainings that I've been to, but also my own experience. When direct is going well, and I'm sitting at counsel table and my client or one of our witnesses is in the witness stand, I can actually imagine myself disappearing. And that's not necessarily my normal mode in a courtroom, but like I can feel myself sort of shrinking and getting quieter and disappearing, and all of the focus is on the witness or the client. That's the opposite of what we're going to talk about when we talk about cross-examination. And I don't know if it's helpful, but for me, it's just helpful to imagine literally getting smaller and quieter in the courtroom. But regardless of that, like I think the more important thing is that you want all of the relevant information to come from your client and from your witness. And so you use open-ended, non-leading questions. Like a really good direct question is, and then what happened? Right? I mean, that's because all of the information is going to follow, and nobody, the jury and the judge isn't going to be riveted by you saying, and then what happened? It's like, where were you? You know, where was the other person? Those are good questions. So, you know, why did you get this restraining order is a much better question than, was there an incident on July 11th, 2024 that caused you to be afraid? Because once you start talking in direct, everything moves towards you, and you're not really allowed to be testifying. And so just trying to figure out how, you know, your client's kind of ability to tell their story, to describe what happened, the witness's ability to do that. And there's a wide range of testimony styles that will work. So you have to not, you have to be, you know, realistic about the fact that different people talk about things in different ways. And some people talk in paragraphs and some people talk in monosyllables. And so trying to figure out how to expand the shorter answer people and how to contract the longer answer people is part of the magic, but also not trying to make people someone that they're not. That's kind of how that preparation goes. And so, and also just going back to what Melanie was saying, I always, even if someone else has been working with a witness or a client on what it's like, I always tell them to kind of sit up, you know, put your butt back in the back of your chair and put your feet flat on the floor. If you're someone who, like me, who waves your hands, you know, in a way that, you know, could be distracting, I tell them to hold, you know, put their hands, like hold their hands or put their hands on their knees. But most importantly, as Melanie was saying, you look at the decider, right? You're not talking to me, you're not talking to the translator. The witness should be talking to the jury or talking to the judge. And that's hard because sometimes it makes people more nervous. If they know you, they want to look at you, and that's okay. I mean, it's not like, but ideally those things, you know, are really sort of part of that direct examination dynamic. And I will stop talking about that.
Yeah, so I find it useful in direct and cross, which we'll talk about, to have, of course, you have an outline that you've worked on before, and you've ideally been able to practice with your client, and maybe you've been able to practice with some other witnesses too. But an important part of that outline is like, what are the key things that you need from this witness to win your case, right? Because you have to get those things out, even if the testimony swerves in a way that you didn't expect, which in my experience, it often will. You could have been representing a client for years, and there still can be surprises when you are asking them a question on direct examination. It's amazing. So just really knowing, okay, these are the parts of the case that have to come from my client. The evidence can't come from anybody else. And it's really essential that I get those out. And then, of course, you're going to put those in the form of a story because you want the jury to hear the story and you want the jury to understand your client as a human being. And the moments of real connection between the jury and the judge, judges have better poker faces, but the judge too, is when those like glimmers of your client's personality and humanity come through when they're telling the story. So Melanie, I'm thinking of when we were asking Julio questions about why he was going out to buy the takeout meals. And he was just like, well, I'm a man, I don't really know how to cook. And like every person on the jury sort of smiled and like made this little connection to him. And we didn't plan that, you know, I mean, that's just, so there's, I think part of what Ed's saying about asking open-ended questions, you're sort of giving the client some space to be themselves and be a person that the jury or the judge will feel a connection to and empathy for. That's really important. So some things that I have had to do in trials that I didn't expect to do. Sometimes you have to examine a witness that you have not had time to prepare with. So that can be because, so for example, in this case that we did in Polk County recently, we wanted to get testimony from the client's treating physician. And so we tried to contact her and it ended up with the risk management folks who said, you can send a subpoena, she'll come, but she's not gonna talk to you ahead of time. They just sort of, you know, blocked us. So we decided it was worth, you know, rolling the dice. We sent the subpoena. She did show up. We did, you know, 7 minutes of prep in the hallway of the courtroom. And then she gave wonderful testimony, really, you know, really helpful testimony. And so figuring out how you're going to handle that is, in a case where you know you might have a witness that falls into that category, is one important thing. And I mean, they say like you should never ask a question you don't know the answer to, but like you can't always do that, right? If you haven't talked to the person ahead of time. Yeah. So what did that 7 minutes of prep look like? So we had a stack of medical records that we were going to ask her questions about. So we used those and we just went through them with her. And we explained the reason we needed her there is we needed her to say that this child, who already was having a lot of difficulties before this particular incident, had different and more severe difficulties after the incident, including a new PTSD diagnosis. And so that's what we were talking to her about. Like, do you remember this visit? Do you remember this visit? What would you say about, you know, the way that his X, Y, or Z health condition or disability was showing up before and after? What would you say if I asked you if there was a clear difference before and after? Those kinds of questions. And what I said about having a list of like, here's what I need from this witness, that was super useful because that's what we knew we needed from her. And so all of the prep focused on that. And then we didn't ask her questions in that prep session about like, how long have you been treating him and all of that? We just like sort of asked those questions on the fly, because if the answers to those questions are different from what you expect, it's not such a big deal. But those key things you really need to know. So that's how we did that prep in the hall. So also a thing that I had not really thought of before that we did was we called adverse parties as part of our case in chief. So sometimes you need evidence that really can only come from the other side as part of meeting your burden of production and your burden of proof. And so I had not thought about doing that before. And in fact, we called witnesses in our case in chief that were employees of the school district that had not been deposed, which felt really wild. And the way that we did it, the way that I think you can do it without a deposition, is if you have documents and you hew very closely to what their written statements have been. So if you've gotten something in discovery that you know they wrote and you can sort of marry them to that and guide the testimony along through direct that way, that can be effective. The last thing I'll say is that I said that things will swerve. They can swerve in that answer that surprises you. That, of course, can happen in cross-examination when someone else is cross-examining your witness, but it can happen in your direct examination too. And other surprising things will happen too that you'll have to correct for. So I'm just going to share a story about that, which is that the most extreme version of this happened to me in an FED trial that I did with Ed that was online during COVID. And it was that my client was in the middle of testifying under oath, and then she left to chase a dog down the street while we were all just sitting there waiting, and the judge was asking where she had gone. And I wasn't with her. We were all remote. So whenever something goes a little bit sideways in a hearing or trial now, I think, well, at least my client didn't just like flee off the stand in the middle of her testimony.
Melanie, do you have anything you want to add to that about watching our clients testify or?
Yeah, I guess just quickly, what just kind of reiterating something that Kelsey said. I think it definitely, from the observer's point of view, is like a continuation of your opening statement. And really, Kelsey did a great job of furthering. I think it's a great opportunity to either side really wants to humanize their client and ask those questions that are going to start to get the jury on board with why your position is the right position. And I think Kelsey will probably get more into this during the cross-examination, but it definitely does. There's things that you're pulling from a client. So I think also keeping in mind that you're going to have to ask similar questions in 5 different ways in order to maybe pull the answer that you wanted out of your client is just a skill that I imagine really has to be honed. Because you have to rephrase continuously, because something that we practice over and over and our client would tell us, yes, I definitely will say that in court, we will not get out of them sometimes, even if you ask it 3 different ways. So it just really is trying your hardest to push through, like getting that answer out of them without, directly, I guess, asking them some things. But yeah, it's a skill that was really great watching Kelsey and Emily do, learning how to ask a question in 5 different ways until we got what we wanted.
There's a question in the chat that I think is super related to that, Melanie. So it's, what are some good ways to avoid leading questions if your client is nervous and forgetting what they should talk about, especially if refreshed recollection is not possible? Or is it always possible to refresh a witness's memory in real time? So that's kind of a 2-part question. I think the first thing that I would say is, I think a lot of times people's idea of what a leading question is bigger than what a leading question really is. So appropriate questions on direct can be very direct. They can be specific. You can ask about a detail. All of that is allowed. You just aren't allowed to say things like, you were scared, right? You feared for your life, right? But you can say, you can kind of break it down. So and what happened next doesn't work, you can, to Melanie's point, break it down into the subject areas you're talking about, right? Did you get anything in the mail after that? Where were you when you had the phone conversation? There's all kinds of ways to kind of break that down. Refresh recollection, I mean, it depends on what you have to refresh their recollection with. If you have something to refresh their recollection with and they say they can't remember, you can always ask if you can refresh their recollection. But you can't refresh their recollection by being like, hey, remember when we practiced this and you told me this? Does that refresh your recollection? Ed, do you have things to say in response to the question?
No, I think you and Melanie covered it. I mean, the only like additional layer is it depends on how important the testimony is. If it's really important, you just keep trying, getting more and more leading and directive until you get an objection and the judge tells you to stop. If it's not that important, you just kind of move on. Sometimes you can loop back to it later. But It does happen quite a lot. So that's a really good question. Okay, should we shift over to trial objections? Okay. So this isn't really chronological because trial objections can happen at any point during trial, but and I think we have evidence as a separate basic skills training. If we don't, we should. And hopefully Steve is participating in that. He's kind of a roving parlor trick of evidence knowledge. He's like knows the rule numbers and things like that. But you don't have to. It's not, I mean, in order to like sort of be prepared for basic trial objections, there's really only a handful of things that come up regularly. And that's 99% of what is going to happen in a courtroom. The 1% is so hard to predict that I wouldn't worry about those sort of outliers. So I'm going to talk about some of the main categories, but I will also just again point out that for better or worse, people have done a lot of studies about judge trials and jury trials, and those studies seem to indicate that juries do not like objections. They think it's rude, and they will often sort of form an unfavorable opinion of a lawyer who over objects. So even though I know that that piece of information is out there, for the most part, I do the same thing in front of judges and juries, with a couple of exceptions that I'll mention at the end. But I'm going to start with, I'm going to move from things that I always object to things that I rarely object to. So the thing that I will always object to is privileged communications. So I mean, that should be at the very top of your brain. Your objection brain is like, if a witness starts talking about something that, a communication with a lawyer or a doctor or a counselor, I mean, it's not always going to be privileged, but that's a good time to sort of raise it. I mean, ideally after the question is asked, but so that's kind of the top line, is privileged testimony. And then there's the biggest category of objections, which I'm going to call hearsay, even though it's a little more complicated than that. I mean, my brain, I don't know if anyone else is in this, but like I can be not working and I hear hearsay. So you just have to activate that part of your brain when you're in a courtroom, that if somebody's talking about somebody else talking, it's hearsay. If somebody's saying, I heard, somebody said something and that person's not in the courtroom, that's hearsay. But also, you should be aware of what I call hearsay on the horizon, which comes up all the time in our cases. And so what I call hearsay on the horizon is a witness, usually an adverse witness. I mean, it can be our witness, which is the opposite situation. But if it's an adverse witness starts talking about some event and they weren't present for it, but they haven't actually mentioned any hearsay yet. They're just talking about something that they weren't there for. That's a perfect time for a question in aid of objection. In fact, I would say 90% of the questions in aid of objection that I've ever made are in this scenario. And so it's really simple. This witness on the other side is talking about something that happened, and from discovery that they weren't there for this incident. And so you just say, Your Honor, I'd like to ask a question in aid of objection. The judge always says yes. And you say, were you present for this incident that you're describing for the court or the jury? And they say no. And then I usually just say, I'm going to object to this as all being hearsay. Now, whether it is all technically hearsay or not, we don't really know how this person knows about this thing, but it probably is. Sometimes the judge will help you out and ask the next question. Sometimes the judge will just say sustain. But usually it derails that conversation. So, I mean, there's more to say about hearsay. It's a very complicated rule, but that's a rule that's worth taking a look at before trial. The rest of these are kind of, they come up, but they're somewhat amorphous. So form objections, I don't love them in front of a judge or in front of a jury. And so, when I say form objections, I'm talking about, leading, compound, calls for speculation. I've noticed, some sort of family law attorneys on the other side of our cases, landlords attorneys, they like to do that. I don't know if I'm not sure what the purpose of that is exactly, because, if you're on the receiving end of those, you just re-ask your question. It's possible you asked a bad question. But I don't like to, I think that is distracting, because I mean, unless you have a very specific plan for what it is, why you're doing that, you just run a high risk of looking like a jackass. I mean, if the other side asks a compound question, they're probably, I mean, you have to think through, like, is this helping us or hurting us? And if you're not sure, just let it ride for a little while. The one place where I always jump in is where the other side is leading their witness to the point where it's clear that the lawyer has the information and the witness doesn't. I mean, that's a point where you do say, yeah, I usually make some kind of leading objection in that situation. And it often does turn out that all the information is in the lawyer's head, not in the witness's head, in which case you can kind of stop bad stuff from coming in. So, I think that, I mean, there's more to say about that, but then there's the whole universe of relevance objections, is sort of the last big category that I want to talk about. And here I think there is a big difference between a judge and a jury. So, I mean, you can make a relevance objection at any moment for a variety of reasons, and often they are overruled, and that's okay. In front of judges, I mean, over the years, I've had many judges sort of look at me like, how long are you going to let this nonsense go on? I have other things to do with my life. I mean, that's a look you should be ready for. And it usually means, Your Honor, I'm going to object to this. This is irrelevant. We could be here all day talking about whatever this is. But juries, I think, this is a place where I think there is a difference. Like, and I don't necessarily, I think juries also don't like to have their time wasted. And if it's not hurting you and the other side has chosen to use their time to talk about things that are not relevant, I will usually just let that go. I will also just say a little bit about, it's sometimes that something is probably on the relevant side, but it's not good for you, and the other side is in a flow, and it's also not like super relevant. And I will say, objection, this is all irrelevant, which, by the way, is an improper speaking objection. The proper objection is objection relevance. But I 90% of the time get away with objection, this is all irrelevant, objection, this is all hearsay. It's kind of like an arguing objection. You're not supposed to do that. If you're in front of a strict judge, you shouldn't do that. But it gives you a chance to, I mean, you got to pick your spots, but that can be a very effective way to, like, point out the possibility that this isn't super relevant. It also can interrupt the flow that the other side has going. So I think I will leave it there and remind everyone that we are actually going to do an evidence training. So this is just about, like, when to object in the courtroom.
So the thing I'll say about this is, so the theme for me of whether I enjoy a part of trial is how much control do I have over what's happening. So I love opening, I love closing. I like direct pretty well. I hate this part. I hate the idea that, like, at any time something could happen and I need to know, like, I need to make the split-second decision about whether to object. I need to know why. And, like, so I do a lot of sort of, before both of my trials, I did a mini, like, as though I were back in law school. I, like, went back and I reviewed all the evidence rules, and I made myself little, like, cheat sheets, and I, like, just to get it all back in my head, what all the different things were. And then, of course, all of that anxiety is, like, it's it's pretty useless because I mean, it makes me be more prepared, so I guess that's helpful. But most of the time, it is the rare case where it's like critical that you object to something. And if it is, you're probably gonna know, right? Like you know what the big things are that shouldn't come in. Because you're going to be familiar with the record in the case, and so you know what the landmines are. So, for example, in the case that that I did in May, I knew that there was a CPS report that had a bunch of stuff in it. Most of the things were unfounded. There was one incident of domestic violence that the other side was trying to say was the real cause of the trauma for this kiddo rather than what had happened at school. And so I was worried about all kinds of things I would have to object to, but I was ready if they tried to get that thing in, right? I had a long list of reasons why that was not admissible. And you will be too for the things that are likeliest to be a problem. So it's all marginal. And you're also making judgment calls in the moment. So like Ed said, if your opponent is doing something that you could object to, but it's not going great for them, maybe just let them do it. And then you're not sort of spending your precious objections, especially if you're in a jury trial, on something that isn't causing you that much damage anyway. The other thing I will say is that in the context of a trial, I think the rule of evidence that I had oversimplified, that I now understand a lot better, was Rule 403, which I always thought of as like probative prejudice, but there are all these other reasons you can keep relevant evidence out, and they're often easier to prove than unfair prejudice. Things like it's going to mislead the jury, it's going to be confusing, it's going to take a really long time, it's duplicative, it's cumulative. And so I would spend some time with that rule before you're going to be in a proceeding, because you can limit. You might not be able to keep it out entirely, but you can limit testimony on stuff that's not good for you by leaning on that rule. And often you can do it by leaning on the parts of the rule that are not about prejudice.
A couple of questions in the chat. Gabriel asked about when do you stop a client from speaking? That comes up a lot. And I think another related question is how do you stop a client?
Yeah.
I mean, the person in the witness stand is to some degree in charge of how much they talk. And if they don't look at you, you can't stop them by hand gesture. And then you have to, if you do decide to do that, you have to decide which hand gesture. Like there's no real polite like sign language for stop talking. So, but I do, I have interrupted clients, and the nice way to do it is to say, thank you. Let me ask you about X. But sometimes judges don't like that. And I've also been kind of lightly reprimanded for interrupting a client. So yeah, that's a great question with no easy answer, I think. Do you have thoughts on that, Kelsey?
Yeah, the thing I would add is like, I think it really depends, like, how's it going for them to talk uninterrupted?
Yeah.
If it's going great, if this guy talked about all the stuff that you prepped and it doesn't sound like he was like reading a rehearsed speech, ask one question and let that be his direct examination. That seems fine for him to just like tell his story. But if it's not going great, or if they're veering in a territory you don't want, or if it just feels sort of like stilted and rehearsed, then I think you would want to try to gently interrupt. But I can totally imagine a situation where it's like, it's fine for the client to talk a long time, as long as they're sort of staying on track.
Yeah, I agree with that. Although what came to my mind were times where it was not fine.
Yeah, well, sure. Yeah, yeah, that's difficult. But that can happen in response to a short question too. I mean, in a short answer as well.
I mean, that's why that back and forth. I say to people when I'm prepping for direct, I say this is a back and forth process where if you stop talking, I will ask the next question. That's what I do.
Yeah.
And so it's okay to just give a sentence. I will ask another question. You know, I will make sure we get through everything. You don't have to worry that I'm going to forget what we need to get through. So, but that doesn't always work, maybe because they think I won't, that I'm not able to do that. But I do, yeah, I mean, that happens very frequently. So, and it's kind of case by case. So Rohan has a question about do you say objection basis? Yes. So the proper way to make any objection is objection, hearsay. And usually what happens is the judge will look to the other lawyer, or the judge will just rule on it. Like if the judge knows for sure, the judge will just say sustained or overruled. Sometimes the judge will say, tell me more about this hearsay. Or something, you know, or if you don't like the ruling, you can always say, can I make a brief argument about that? And the judge will sometimes say yes or sometimes say no. But you're really not supposed to just start arguing without some sort of communication with the judge that they want to hear more about that. I think that answers that question.
Yeah, and that's, I mean, I know I said we're going to talk about jury trials at the end, but that's especially true in a jury trial because that argument might need to take place not in front of the jury. And so you have to wait until the judge decides if it's going to happen in front of the jury or not.
Yeah. Okay, Gravir asks, is it fine to concede to an objection if the objection is credible and there's no way around it? So, I mean, I have said the word withdrawn in court before, and it doesn't feel great. And I've also had a judge say, Mr. Johnson, this is not television after I withdraw a question. So I usually don't have to like formally concede. Usually what just happens is the other side's objection is sustained and I move on.
Yeah.
There's no way I mean, you could just say, I'm sorry, I'm wrong. But I think I don't do that. But I have tried to withdraw questions that I know were bad questions. And that's at that point, you're just like making matters worse, in my opinion.
Yeah, because it feels like, because on TV, it's such a like mic drop, right? Like they ask the question they know they're not allowed to ask so that the jury will imagine the answer. And then they're like, oh,
yeah,
you don't even need to answer that. Everyone knows what the answer is, right?
So Nargis is asking about an interpreter, and we did touch on it briefly. Melanie was talking about prepping a witness who was using an interpreter and the importance of looking at the finder of fact instead of the interpreter. And you know, I will just say as a non-Spanish speaking lawyer that you know, I've had to learn over the years that having an extra person in the room and sort of that triangulated conversation my main takeaway is that you just have to slow yourself down and just be patient for that three-angled conversation to take place. I mean, Eleanor, you know, I will also say that and again, this is coming from someone who speaks very limited Spanish, certainly no court Spanish, is that, you know, often the interpretation that I've gotten from my coworkers is better and different than what I've gotten in a courtroom. And so just being prepared for the fact that the way that something is interpreted in prep may be different from the way it's interpreted in a courtroom is a whole nother universe. And again, like, since I don't speak Spanish, I'm at a disadvantage. I can't, you know, I'm not in a position to argue with the interpretation. Other than I can tell when it's different, and I'm just like, well, that didn't go the way I thought it was going to go. But, Kelsey, do you have thoughts about that?
Yeah, I mean, I think it would have to be a pretty extraordinary situation where you would argue with the interpretation. But I think what's helpful if you happen to be bilingual is you can ask more questions to get your client to say more. And I guess you could do that if you're not bilingual too. Like if the client has told you something different, then maybe they did say something slightly different. You know, maybe it's interpretation, maybe it's they're saying something slightly different, and maybe you just need to ask, to Melanie's point, the same question 5 different ways so that you get all of the information out there. Obviously, if the interpretation is of very poor quality, you would stop whatever's going on and talk to the judge about it, I think. But, you know, if it's just like they didn't interpret something, it's called interpretation, not translation for a reason. Like if they didn't interpret something exactly the way that, you know, the person who works for us interpreted it and it's the same sentence, like that doesn't actually necessarily mean it's incorrect.
I've seen lawyers, you know, object to, you know, and just say, Your Honor, I have a question for the interpreter and talk through that. Of course, I'm not in a position to do that, but I mean, there is kind of a way to do that you can usually get away with. You don't argue with the interpreter. I use the wrong phrase. But you just say, Your Honor, is it okay if I ask the interpreter a question about how that got interpreted?
And Nellie's saying something different, which is that they've objected to interpretation, and it's usually pretty effective, especially when talking about threats and talking about, you know, these like really crucial, sensitive things and restraining orders. Yeah, and it can like kick the interpreter up into a higher gear.
I've wanted to do that. I have not had the skills that I needed. I have one example in mind, and I can't remember what the Spanish word was, but Eleanor in our office had repeatedly translated something as "open the fucking door." This guy was yelling. It was a restraining order hearing, and it came out in the hearing as like "open the damn door," and it was like the way it was said in the word was like, "Are you kidding?" I mean, the whole thing just like really sounded much less threatening, and so, but I was just sitting there like I didn't, you know, it's good to speak Spanish.
Yeah, I mean, certain things like curse words are inherent. It's like impossible to really do interpretation, right? Because the weight of the word, like there's no equivalent with the same weight and the same, that's hard to do. All right, we have another question. I know this isn't directly on point to trials, but can you make objections during oral argument on motions? I assume yes, if there's testimony, but what about objections during the opposing party's argument itself? I cannot imagine a situation where I would interrupt the other attorney. I mean, maybe a really extreme example where I would interrupt the other attorney to object. An oral argument and a motion, usually both sides are going to get a chance to talk in turn, and you sort of follow those rules according to how the judge is managing it. Like you'll get a chance to say why you disagree, and you can say like that's an improper argument because X, but you don't have to interrupt in the same way that you would in a trial.
Yeah, I agree with that completely. I think we should just keep going here. We're running, not surprisingly, we're running a little bit behind. And so if anybody needs to get up and stretch, please do so. But we're going to plow it here so we can be done by 3.
Yeah.
Should we move to cross-examination?
Yes.
So much to say, but I will just hit the obvious points. I mean, you know, cross-examination is probably the most glamorous, theoretically, the most glamorous part of trial practice. That's why on TV and movies, it seems like it's like 90% cross-examination and no direct examination. But it's the truth of the reality of cross-examination is less glamorous. And I think the most important sort of umbrella point is we prove our cases through our clients and our witnesses. And it's very, very, very rare that we're going to prove our cases through the other side's witnesses. But what you're trying to do is limit, discredit, and undermine the effectiveness of the other side's witnesses. And there's kind of back when violent imagery was all the craze and I was learning about trial practice, there was a common saying that cross-examination is more often suicidal than homicidal. I'm not sure that that's a great phrase, but I don't know how else to say it. It's just true that you like, and there used to be these CLEs on killer cross-examination. I guess everything was killer, but the truth is you can really there's a high potential for doing more harm than good on cross-examination. And in general, the times when our witnesses are on the stand are better than the times when the other witnesses are on the stand. And so you should be thinking, I want this person off the stand. I mean, that's kind of like the starting point of cross-examination. But yet I do like to cross-examine every witness if I have some plan and some idea that I can sort of impact the value of that person's testimony. And so sometimes it's just one thing. But let me talk a little bit about the skills of cross-examination. It's the opposite of direct examination. When I was talking about direct, I was talking about how I could, like, I imagine myself shrinking and disappearing and getting quieter. Effective cross-examination is all about you. You're the one who's testifying. And so you don't want to be a jerk, because there's a fine line between effective cross-examination and kind of looking like a jerk in the courtroom. So you have to sort of figure out what your style is. But the important thing to remember is all of the important information is coming out of your mouth, and your goal is to get the witness to say yes to whatever it is you're saying. And the second part of that is when they don't say yes, and there's an opportunity, you want to incentivize them to say yes going forward. And there's a lot of different ways that can play out. And I'll talk about some of them. But in general, I like single fact statements. That's kind of how I set up cross-examination. And I'll try to do a short demonstration in a moment with Kelsey that we have not rehearsed, which will be a good example of high risk cross-examination. But the important thing is to have a plan and to have a goal of what it is that you're hoping to accomplish. And I think when I think about the adverse witnesses, there's kind of a risk spectrum. And like Kelsey was saying earlier, in state court, you don't even know who these witnesses are. If you don't know who this person is, and you don't have documentation about what they did at a certain time or said, and you've never deposed them, that's a high risk witness. And you should just be in your mind thinking, I could make a bad situation worse here. On the other hand, if you have prior statements of this witness, often from deposition, that starts to move down to the lower risk end. If you have things that are admissible about this person, like prior criminal convictions, things like that, those can be, lower risk. And sometimes just one question about that suggests bias can be really effective. Like, for example, if the adverse party's family member testifies, and again, like, you don't have to do it in front of a judge usually, but in front of a jury, I will often say, you're married to the landlord, correct? Just as a reminder that, like, this is not some neutral person, not a neutral eyewitness to something. In cases I do through the Domestic Violence Project, if the respondent has had other restraining orders against them, pointing that out, just saying, my client's not the first person to get a restraining order against you, is she? That's a good cross-examination question. I always put the best piece of cross that I have last. And that came from learning in court that, a lot of cross just falls flat, and it just feels bad to say no further questions after something didn't work. And so, like, it's better to just if you have one thing that you're pretty sure is going to work, like a conviction or some clear contradiction, I always put that at the very end. The other thing that comes up, and this is complicated, this involves a little bit more training than we have time for, but the use of deposition testimony and cross-examination comes up a lot. And on the one hand, it's pretty simple, but it does involve practice if you've never done it. And so I'm just going to walk through generally how it works. But it starts by, so it kind of violates my rule of the, and again, like, when I say I make short declarative statements on cross, it's not exclusively that. I do ask people questions. Sometimes witnesses will say, is that a question? And I'll say yes, even if it really wasn't a question. But sometimes I do ask questions. And if you're going to use deposition, and you have, like, so the idea of setting somebody up for a cross-examination using their deposition is they said something that was helpful for you in deposition. And so the way to set that up at trial is you ask the exact same question in trial. So that's usually going to be a friendlier, more open-ended question. And sometimes the person will say the helpful thing again, in which case you move on. But quite often, the person has spoken to their attorney, rethought the wisdom of their deposition testimony, and gives a very different answer in trial. And so then there's this whole little performance piece that you do as the lawyer, which starts with, remember back in June when I took your deposition? Usually the answer to that is yes. We were in my office or your attorney's office. And remember, you were under oath that day? Yes. I'm going to read from your deposition transcript. Question, I read it. Answer, I read it, and I just move on. People often want to ask another question at the end of that, and that's where things go wrong. All you're doing is pointing out to the judge or the jury that this person said something different under oath before. You don't want to ask the next question, why is your answer different today? Because often there's some explanation for that. The differing testimonies sort of speak for themselves. So I also love, I'm just reading Trina's observation. I also love watching the other attorney make their case worse. But that sort of goes to the original point, which is when our client's on the stand, the odds of good things happening are much higher than when the other side's client and witnesses are on the stand. So, okay, Kelsey, are we going to try to demonstrate these things?
Yeah, sure. Do you want to do that first? Or do you want me? I have really only one thing to add about this. Do you want me to do that first and then we can practice? So what I would say is I just want to share, because I suspect there are other people who feel this way, that I really dislike cross-examination. And it's not because it feels high risk. I actually think, I mean, it is high risk, but like if you have a plan and you've got a document or whatever thing, right, then you have some amount of control over what's going to happen. The reason I really dislike cross-examination is I do not like making another human being uncomfortable on purpose. And that is exactly what cross-examination is. And it's just a super important part of the job. And if you, like me, some people love it. Some people sort of thrive on that energy. I do not. I don't think you have to love it to be good at it. In fact, I think not loving it can make you be judicious in your use of cross-examination.
Yeah, now I feel bad that I do kind of love it, but I don't think of myself as someone who likes to make people feel uncomfortable in public. Anyone on the other side is the great environment. I mean, it is an adversarial process. It brings out the worst in me, but yeah, when we had Judge Mossman come and talk at trial advocacy skills training a few years back. We are going to do that again. That's a week-long training. But he was a U.S. attorney for a while, and he was saying his favorite trial moment was he was cross-examining some witness and got some really good testimony, and he heard the opposing counsel make this noise like really bad. So that was my favorite moment. It's like, oh, maybe I'm not such a bad person.
We have one question in the chat, which is good. In the situation in which you're reading depo testimony during cross, how do you end the interaction? So you just said you stop, but I've also done it and heard it done. And that was your sworn testimony that day, wasn't it?
Yeah. You can do that. And
yeah.
But I often will just move on to the next thing and leave it there. It's not technically a question, but usually the point has been made. And depending on where you are and what kind of trial it is, the depo testimony may be admitted as evidence, not just used as a cross device. So,
yeah.
Okay, I'm going to try to just ask 1 minute of direct questions?
I agree with this feedback, Ed. When you sit back, you get a little quiet. So if you can make sure you stay forward so people can hear you.
It's gonna be hard for me to demonstrate direct when I talk about getting quiet and shrinking. And
Well, it could be useful to do it under that circumstance, I guess, but
sorry about that. Yeah, I don't know what's going on with my audio. I think if I'm too far away from my laptop, that might be my issue. But all right, let's try. Let's just try. It's like improv class now all of a sudden. But so we're going to pretend that Kelsey was just sworn in as a direct witness, first of all, and I'm just going to ask her a few questions. So, Ms. Heilman, what do you do for work?
I'm an attorney,
And where do you work?
Oregon Law Center.
Have you done any trials recently?
Yes.
Why don't you tell us a little bit about that?
So I tried a case to a jury in December in federal court. That case was an employment case. It involved claims of unpaid wages and unlawful retaliation for using protected COVID-19 sick leave during the pandemic. And then the second trial was in state court in Polk County, and it was a tort claim against a school district that failed to keep my client safe at school according to the terms of his safety plan.
Okay. So, I mean, again, like there's not much to demonstrate there, but Kelsey would be a very good witness for us because she, provides all the information there. If I were going to try to take that information and turn it into cross, it would be the opposite of that. So I would say something like, Ms. Heilman, good afternoon. You claim to be an attorney at law. Is that correct?
Yes.
And in December of last year, you sued a small business owner over some alleged employment violation.
I had an employment case in federal court, yes.
And just a few months later, you turned around and you sued a school.
Oh, well, the lawsuit was filed long before the trial, so it wasn't a few months later.
A few months later, you tried a case where you had sued a school right after suing a small business owner who was providing jobs in our community. Is it safe to say that you would essentially sue anyone?
No.
No is not the suboptimal answer. That was terrible. I mean, you kind of have to, you get the idea though, that it's, and maybe if we had prepared that at some point, it would be more effective. But essentially, the difference is all of the information is coming out of my mouth. And if the witness on cross starts to argue with you, that's okay. I mean, that's not the worst result. And you can also ask the judge for help if the witness is completely non-responsive. So there's ways to kind of guide the witness back to saying yes. But I often sort of the opposite of what I was saying before about saving the best piece of cross for last. If I know for sure that this is going to be a weaselly witness who's likely to change, their story or lie about something, I try to put something like that up front too, and then, use the deposition testimony or the prior testimony or whatever it is to kind of incentivize the answer yes going forward. So I think that's all I have to say about that.
Yeah. I think the final thing about cross is just thinking about the different ways that you want to like there might be witnesses you're cross-examining who you want to try to cast for the jury or the judge as like the big villain. And then there might be other adverse witnesses who are like, you'd rather they be seen as like other victims of the big villain's malfeasance, even if they're testifying in a way that doesn't help your client. And so that can affect the kinds of questions that you ask. So, in an employment case, if you're interviewing people who still work for the company who are providing adverse testimony, you can ask questions about, like, you like your job, right? You want to keep your job. You were promoted after, my client was fired, those kinds of questions, which are not like you're a bad guy. It's just like for the jury to think like, oh, what are this person's motivations? We have a question. I have always heard and both your direct and cross on your punchiest questions. I have not heard that advice. Have you heard that advice, Ed?
I mean, certainly cross, that's kind of what I was trying to get across before, no pun intended, but with direct, not necessarily on direct. I think with direct, it's more of a narrative arc is the way I think of most direct, is just kind of going through the chronology of it. Now redirect, which is oddly not on our agenda today.
Oh yeah.
That is often a place, especially if the other side does damage on cross. Redirect is a place where you want to end it on a high note. Redirect is a whole different art, but I think on redirect it really is important to get back to the core part of the testimony. If things start to get sort of dispersed through cross-examination, a lot of times getting back to that core point and ending on the most important point is a good is sort of a good plan for redirect. I also think laughter is the best testimony. Okay, where are we?
Tech.
Boy, this is where I go mute.
Okay, so I can talk about tech a little bit. So the really great thing about the trial that I assisted Kelsey with in federal court is that the courtroom we were utilizing, and Ed kind of alluded to this, had really great tech setup. So it made it really fun and really easy to work with. But we had a case where we really did utilize a lot of tech to support our case. So one important thing that I learned and kept in mind was that you want to pay attention ahead of time to make sure that if you are using tech, that your files are in the appropriate format. So I had to go in and convert a lot of our exhibits and things that we were going to use into PDF formats because it's kind of the easiest way to toggle back and forth without people kind of seeing your entire computer history and stuff that you don't want them to be paying attention to, and just focus on the neat presentation of your case. So after converting everything into PDF, and maybe some more technically savvy people would figure a way around this, because I am decent with technology, but I wouldn't say I'm the greatest. One thing that I just ended up doing was the setup that they had was a clicker, so I could click on and off all the screens that were in the courtroom. So I ended up basically where you save all your files in the little file clip at the bottom of some of your computers. I had that open the entire time, and when I would toggle back and forth, would click off everyone's television, and then once I was on the appropriate file, would click on back onto it. In general, that allowed for about like 20 to 30 seconds. I was saying, Kelsey can correct me if I'm wrong, between when I was pulling up something and by the time people saw it, it was about 20, 30 seconds. So not a lot of downtime in between them, I think, maybe, unless some of them took a
I
little.
think it was shorter than that. I
Okay.
think it was more like 5 to 10 seconds.
Okay, I was giving myself a little bit more leeway, but yeah, so I think having it at least, so what I basically did was save everything on a separate file. I had that file open the entire time so I could just see the list of exhibits. Another nice thing, I think, whether you're doing this kind of on your own or if you have a second person there to help you, is ahead of time, Emily, Teplin Fox, and Kelsey were able to give me an outline of what exhibits they would presenting at what points of the trial. So I kind of had an outline that said, okay, once they ask this question, exhibit 3 should be up. And that kind of just helps you keep in line shorten the amount of time between showing the exhibits and pulling them down. There were definitely times when Kelsey or Emily would just tell me, okay, we can take that down now. But I think having them up for the duration of like cross and direct really also helped outline to the jury what it is that they should be focusing on. So that was a big thing. I don't know if this necessarily falls under tech, but as Ed was showing the poster boards, We did utilize poster boards on ours. It also, I would say maybe helps having a second person there because I was able to help Emily hold it up while she focused on doing the, going back and forth to the witnesses, looking back at the poster board, and then I just had the job of showing the jury the entire time what they were supposed to be looking at. And then I guess this is dependent on how much people want to play around with tech, but something that I noted was, especially I think for an employment law type of case or something where that involves a lot of events, the jury responded really well to our calendar that we had, which, as Kelsey mentioned earlier, was the only thing that kind of was more in depth that had to do with tech. We added animation so that after every point was made, something new would pop up on screen. And I think, in my opinion, I think that is something that the jury really responded to well because they were able to see that at the beginning of the trial all the way through the end. And was a visual that they kind of had the entire time. I don't know if you have anything else, Kelsey.
So this isn't really about tech, but we're kind of talking about demonstratives is in connection with tech, and we didn't really talk about demonstratives. Ed talked about some types of demonstratives like the timeline, but what we haven't talked about is demonstratives that you update in real time, which I think is a super effective tool to keep the jury engaged. So this case in December was an employment case, and so it involved comparator, like evidence of other employees, what happened to other employees. And so Emily made a flip chart that was like asked several questions about each employee that they were proposing as a comparator, because they said, like, look at all these other people who took COVID leave and we didn't fire them. And she set up the question so that she would put a red X if it wasn't a match to, if the answer was no, and a green check if the answer was yes. And the end result of that demonstrative, which she built during cross-examination, was that the jury could see this list of employees, and the 2 clients who were fired had a row of green checks and everybody else had a row of red X's. So it really underscored how different the people were who had not suffered this retaliation. And so if there's a simple demonstrative like that you can build, and then during testimony, could be direct, could be cross, that you're updating in real time, I felt like the jury was very engaged with watching, like, how is this going to get filled out? Like, there's just sort of a natural, like, if you think something new is coming and going to appear, that's like an exciting and interesting thing to watch.
Yeah, I've kind of changed my view about using technology in the courtroom. I used to say that, first of all, I'm not techie at all, but I used to say you don't want to have to worry about something not working. You got enough to worry about. And so poster board was like my level of technology. Barely malfunctions. I mean, the worst, the only thing that can happen is you forget to bring it to the court. But I did a trial a while back. I don't know, sometime in the early 2000s with Beth Englander, and one of the witnesses, this is before Zoom, so it's hard to, like, you have to put yourself in a different time zone, but like one of the witnesses was in prison in Kentucky, and we were in federal court, and the video testimony was so, I could just see the jury so riveted on that I kind of changed. I started to think about the power of that. Like there's something, there's, and again, like maybe now it's kind of gone over the arc because everyone's so used to seeing video transmission of human beings that it's not, there's no novelty to it. But what I think is mixing it up keeps the judge or the jury sort of alert and paying attention. And so, just trying to do something for the sake of having a little bit of variety, it is often effective. And sometimes that does involve like a PowerPoint or a short video, or photographs. I mean, those kinds of things like are just being able to get something on front of a screen. It's interesting. Like I almost wonder if now there hasn't been, if the pendulum hasn't swung back the other way, And so people are more riveted by human beings like
Yeah.
testifying than they are. But back then it was like, oh my gosh, this person. And also like when somebody's, wearing their prison clothes in, they're
Yeah.
escorted in handcuffs, it doesn't really matter what the testimony is. But like that whole the experience kind of shifted my way around it. But I would still say like stay within your comfort zone.
Mhm.
I mean, Oregon attorneys are friendly. Like a lot of times, the opposing counsel you'll like work together on tech stuff if you both have to use it. But yeah, you wanna have either someone like Melanie who can focus on that, or have some comfort level yourself with that stuff.
And go practice ahead of time. So every court will let you do like a tech visit where you get to try it. And that's super important because the setup of the screen. So like, for example, if you want to show exhibits that have words on them that you want people to read, it's very important to know how large the words will be on whatever the display is. If it's a TV that's on the wall across the room from the jury box, that's not very helpful for you to display that if everybody's squinting across the room and trying to read, versus in federal court where they have a monitor for every 2 jurors that's right where they can see it. And then Melanie said, sometimes we take the exhibits down. I think it can be helpful to leave an exhibit up for people to see. But if there is an exhibit up that has words on it, people will read that instead of listening. So you just have to be aware that that's what's happening. It might be a situation where you want them to pay attention to that exhibit more than you want them to pay attention to the testimony. And the testimony is just like sort of verifying what the thing is. But if you want them to really pay attention to the words, you need to not have a visual that they're looking at, or at least not a visual with words.
Yeah, that is so true. I remember a trial where opposing party intentionally left a mugshot of one of our witnesses on the Elmo, and it was just sitting there. And finally I just got up and took it down. And then that looks doubly bad. It's like I don't but
Yeah.
staring at it. I'm like, oh God.
Yeah.
Okay, well, there's more to do about that. And I think when we do the live trial advocacy skills training in federal court, there'll be a chance to play around with the Elmo and sort of experiment with that stuff. It's kind of encouraged in the training because, it's not a real trial, so you're willing to try things. All right, well, I'm going to talk a little bit about closing argument, but not a lot, because as I said before, TV focuses on cross-examination and closing, but the reality is most things are done by closing. And so, but there are some things that you can do on closing that are effective. And one of them I've already mentioned, and that's sort of tying up the loop of things that you said on direct. I think one risk of closing is you can go on too long. And everybody is, you have to kind of be aware of what's happened during the trial. A lot of times you don't need to reiterate things. But if there are 2 or 3 key factual points or 2 or 3 key legal points that you raised in your opening, closing is a good time to remind them, remember, I told you were going to hear X, and then you heard witness X say X. That's just a good, like, closing that loop is a good way to do it. Also, it is closing argument, so you can argue. And I think people often, like, I've seen a lot of lifeless closing arguments, but most of our cases have an argument point. And I think sometimes, so there's a huge risk of under arguing, but there's also a risk of over arguing. And so, and again, like, you have to kind of know yourself and practice the way that you're going to argue. But I think usually the place you want to be in closing is you want to reiterate the main argument of the case, but you don't want to be in a position where you have to yell it and wave your arms, right? I mean, a lot of times our cases are outrageous and maddening. But by the end of the trial, the judge or the jury should be there, and you don't want to take that space, that outrage space. You want to just remind them that they're outraged, not like be the leading person who's outraged. And so you know, the way that, I mean, again, like it's hard to give a short example, but you can say things like, this is what police misconduct looks like, right? That's argument. You can never say that in opening statement, right? This is what sexual harassment in housing looks like, right? Our client was afraid anybody would be afraid. This is not a close case. You know, this is precisely what a hostile living environment looks like. That's argument. But you don't want to overdo that. So, and a lot of time, yeah, I mean, it's there's also kind of there's a judgment call in closing about how much you focus on the other side and what they did or didn't do versus your client. It just depends on the case, but a lot of my cases in housing and police cases and homeless rights cases, it really is that the other side is the bad guy. And so, and that is the main point of the case. And so just saying, you know, not only did the defendant not do the right thing, they did the worst thing they could have done. They did the opposite of what they were supposed to do. Instead of protecting our client who complained about sexual harassment, they decided to evict her. So of all the things they could have done, they did the one thing that was most harmful to the person who was being victimized in their housing. Like that's an example of putting the spotlight on the other side. Sometimes it's the opposite where you're, you know, you want to remind the judge or the jury that your client did the right thing. And sometimes it's both of those. So, and then the last thing, which I think Kelsey just mentioned, is with a jury in particular. With a judge, like a lot of times I mean, if it's a short trial or hearing, you just assume that the judge heard what you just heard. You don't want to insult the judge by trying to like reenact all the testimony in real time during your closing. But you do want to point the judge to the statute and say, this is the issue before you, and here's why you should find X, because we met this element here, and just point that out. With a jury, where you have a verdict form and jury instructions, closing, especially the end of closing, right before they go back into the jury room and do whatever mysterious thing juries do back there, you want to hold up the jury instructions and say, this is what this means. This jury instruction that you just got, this is what this means. Hopefully you've had time to review the jury instructions by then. And then also the verdict form, you know, this is the form that you're going to get, and you're going to answer yes here. That's a no-brainer, right? There's no question that the defendant is liable. And then we've asked for $80,000, which we believe is very reasonable. You get to decide that, but you're going to write in this amount of money that our client gets right here. I mean, that's the way you just walk through it so that they don't get back there and not know how to do that part. And so I don't think I'm going to say anything more about, do ask for an amount of money though. I've made that mistake. We've won trials where I mean, that's my thing. I don't mind making people feel uncomfortable, but because I'm from Indiana, we don't talk about money. So I thought it would be a good idea not to name an amount of money. And it turns out that at least in the first time I did that, that was not a great idea because we got lowballed on damages. But yeah, you do have to get up the courage to ask for a specific amount of money from people.
Yeah. I think deciding what you ask for is a very difficult thing. That in both trials that I worked on changed based on what happened during trial. So you might go in with an idea. I mean, it's easy if it's an economic damages calculation, like then it's just math. But if you're doing any sort of emotional distress, harm, non-economic damages, it's an interesting question how you decide how much to ask for. And I don't know that anybody has totally cracked it. I think, I'm sorry, excuse me. I think walking through the verdict form with the jurors, and also the judge's findings is the best structure because it's just so action oriented. And then each time you can say like, and you heard this, and you heard this, and you heard this. Oh, I really like closing argument. Making the client part of closing argument, and like kind of drawing them in, if you can do it without it feeling too theatrical, I think can be really effective. So, in the Polk County case, the other side really kind of went after my client's mom, as you know, being a bad mom for like letting him play too many video games and some other sort of gross, ridiculous things. And so we directly took that on in closing. And there we put a line in there where I said, you know, I hope you heard her testify, and so I hope you could see her for who she really is, which is a mom fighting hard to protect her kid. And I didn't look at the jury at all when I said that. I looked at her. And it almost made me cry. I mean, it felt very like she teared up. It felt very real, because she had just gone through this like really hard thing, and her kid had to testify, and that was really hard for him. So you have to be careful because you don't want the jury to think you're like shining them on. But if it's real and you can convey it in that way, I think it can be really powerful. And again, sort of like bringing in the humanity of your client. And we're lucky in that way, because almost always we are representing, sometimes we're representing humans against other humans, but very often we're representing humans against an entity, right? Even though they're people who work for that entity. And that's a rhetorically helpful position, I think. And so you want to highlight that.
There was a question about prep time for closing. I mean, it's usually there really isn't any. And so I use my direct as kind of the roadmap for closing a lot of times, or I just throw it out. Sometimes during the course of a trial or hearing, I put a little C in the left-hand column of my legal pad. That means I'm going to want to say something about it in closing. But a lot of times you're right. It's not something like I pace around my apartment and practice direct out loud every time. I mean, that's just the way I prepare for it. But with closing, you're in the courtroom. You're not allowed to pace around in your pajamas and so you essentially have to, you know, do some version. Now for longer trials,
Yeah.
there is, right? So you're asking about less than 1 day trial, right? And it's and so, you know, I think having, you know, having it in the back of your mind and just making little bullet points as you go along of things that you want to remember to hit in closing is the best tip that I have on that.
And again, I mean, I know I said this, but again, using the verdict form or the elements of what the judge needs to find as your outline is, you know, that's something you can do on the fly. In both of the trials that I just did, we got the jury instructions like right before closing, and there were hotly contested substantive battles about what would be in those jury instructions. So it's not like it was just tweaking around the edges. And because we could use those instructions as the structure, you still could like fill in everything into that slot. How directly do you address negatives that the other side was able to get in closing? I think extremely directly. I think embracing, like you have to just like own the thing I love about, so I told you all that I hate the parts where I feel like I have no control, but that's not exactly right, because it's not like I have control during closing, but I really like closing. What I like about closing is all the unknowns are over. Like I know exactly what evidence came in. I know what my client said. I know what happened on cross-examination. I know the worst facts. I know the best facts. Like there's no more question mark about how it's going to come out. And I think the only way is to fully embrace everything that came in. And you can explain why it doesn't matter, but you should not act like you're trying to like hide it or pretend it didn't happen. I don't think.
Yeah, I agree with that. You don't want to hide it. And so if it's a surprise, you need to deal with it in closing. But a lot of times you know it's coming and you can deal with it in opening. And you could even sometimes it's part of jury selection. But you got to get it out there. And there's ways to try to turn that to your advantage by saying the other side's going to say, you're going to hear the other side come in here and testify that, you know, our client isn't perfect, whatever it is, and just get it out there and say, but that's not what this case is about.
Yeah.
And try to like undermine, and that's argument. You can't do that in opening, but but you know, you get the idea. You want to frame that issue if you know it's coming, for sure.
Yeah, yeah.
Um,
And there are ways to frame it up in opening. So at Steve Walter's good advice, so we knew in this case that was about retaliation, you know, our client got an order to quarantine for COVID-19 from the county, stayed home, got fired. The bad thing for him that came out in discovery years later was that while he was on quarantine status, he was still running like kind of a lot of errands outside of his home, and all of that evidence came in, so in the beginning of in opening, we mentioned that evidence was going to come in, and then Steve gave me this great set of phrases, which is I said, but you're going to need to pay attention to what did the employer know and when did they know it. And so then in closing, we could say, you heard a whole lot of testimony about this stuff, but remember, this is about on the day our client was fired. Why was he fired? And so when did they get that information? And then you go through, and the evidence at trial was like overwhelmingly, they didn't know any of that before the termination. It's all after the fact and all, something that they substituted in later as pretext. So I think there are ways to know if you know what the bad stuff is, you can kind of position yourself in opening without arguing by saying like, pay attention to this.
Okay, we have about 5 minutes, so Kelsey and Melanie, do you can feel free to talk about whatever you want.
I think we should just skip the trial motions. I don't know, we were going to talk about motions for a directed verdict and motions in limine and things like that, but I will skip that and maybe say just a couple of things about juries. So
used to put jury stuff up front, and then people would point it out that 99% not jury. So now we put it right at the very end when everyone.
Yeah. So the first thing I would say is if you're doing a jury trial and you haven't done a jury trial before in that court, maybe even before that judge, there's a whole bunch of stuff about jury selection that you have to figure out ahead of time how it works. I did not do this adequately enough in Polk County, and so there were multiple things that happened during jury selection that we just didn't know. Like for example, I didn't know that they were going to assign each juror a number, but then not seat them in order. So, juror 48 was next to juror 12. And so keeping track of the questionnaires and what people's numbers were was really difficult. And we didn't really know how to do it during our questioning. And then opposing counsel caught up, and her first question to each juror was, what's your juror number? Which seems like an obvious way to know who you're talking to, but was not what we had done. So just finding out, where are there juror questionnaires, where are they going to be, how are you going to access them, how much time do you get to ask questions? What's the process for handling for-cause challenges, and then crucially review how peremptories work, because that is another thing that I screwed up, and we ended up losing our chance to challenge a juror that we wanted to get out of the box because we didn't strategically pass when we needed to, so that we would have a chance to bump her. And so rather than get into like the details of what we did wrong and why, I would just say, like, if you're going to do a jury trial, review how peremptories work, and make sure you understand how to use your challenges and when you might want to pass. The other thing I will say is usually the judges will give the jurors good instructions on juror contact with the attorneys. And then the jurors may or may not like follow those rules. So it's really weird. You're in a room and a building with people, sometimes for days, longer. I mean, we don't do trials like this usually, but could do longer trials. It could be for weeks. And you really have to have like no interaction with them. If they try to get in the elevator with you, you like get off and let them be in the elevator by themselves. If they ask you for directions, you're not supposed to, help them with that at all. So that's just a weird thing that I didn't realize would be so extreme, but makes sense. And in fact, opposing counsel in the December case disclosed an ex-party contact with the juror that involved the juror walking up to him and asking him which way to the courtroom, and him putting his hands up and backing away while zipping his lips with his thumb and forefinger.
Yeah, you know, I mean, like most litigators, I think I have a magical ability to pick jurors and also to like bond with juries during voir dire. But the truth is, like, you know, when it comes to jury selection, asking the right questions and listening to the answers is the most effective thing. Otherwise, it just sort of devolves into all your biases coming. One of the last jury trials I did was with Walter Fonseca down in Douglas County, and we had one peremptory left. And I remember us arguing about which of the two guys who had corporate policies with corporate logos on we were supposed to. And it was like down to the logo. It's like, you know what? This is not a high percentage thing we're doing here. But, yeah. So there's more to say about that during trial advocacy skills. Melanie, did you have observations about the jury selection?
No, I mean, the whole process of it is fascinating. I think it is very, you know, as Kelsey was saying, and as Ed was saying, you have to be strategic with some questions. And then it's kind of like you also quickly learn that some jurors are willing to share more than others. And unfortunately, that's when you're like, oh, this is going to be a perfect person for me. And opposing party catches on and they overshare. We had a couple of people, I think, in our December case who we were like, this is going to be great. And then they kind of overshared how great they would be for us. So it's interesting. And sometimes I think at least watching that jury selection, the people that you think are going to be more critical about it, are also kind of going back to Kelsey's short attention span thing, are the people that end up kind of really helping out your case because they're taking the most notes. I think it's always nice. And also, in addition to the stuff about tech we were talking about, seeing a lot of jurors take notes and utilize the stuff we had on screen as note-taking strategies for them was, I think, those two things I would say I as a person observing would really help out your case because they're taking notes on all the points that you're making because you have some type of presentation for them.
Yeah, I think, I mean, I may be biased because I just did 2 jury trials in a row that we won, but I felt very heartened by how seriously everyone seemed to take being a juror. With the one exception of one of our alternates in the Polk County case who slept through, I am not exaggerating, 85% of the trial. I was a little bit surprised the judge didn't say anything, but maybe since he was an alternate, he thought it was fine.
Yeah, when you're winning, you love the jury system.
Yeah, it's great.
Right. But I mean, the truth is, the great thing about the jury system is it's totally unpredictable. And insurance companies in particular freak out about jury trials. So, all right. Thank you all so much for joining us. Thank you, Melanie and Kelsey. And if you have follow-up questions, which is entirely possible, feel free to email us and we will do a longer trial advocacy skills training probably in early 2025. I keep promising, but it is going to happen soon. I promise. So it's good to see you all virtually.